Sorry, the recording just started. There we go. Let me get that. So again, thank you for inviting our office to speak with you all today about the regulation and enforcement of social work in Indiana. Before we get into the specifics, though, I would like to tell you a little bit about the Attorney General's office. Todd Rokita was elected in 2020 as Indiana's Attorney General. As the state's chief legal officer, he oversees a staff of 400 people with one common purpose, and that's to serve with a servant's heart. Attorney General Rokita is known for his willingness to take a stand for what is right, showing Hoosiers exactly how he feels about issues, listening to and speaking up for those whose voices are not always heard. Our office does follow this agenda, and we're always here when Hoosiers are in need. The Attorney General's office functions as the official law firm for the state of Indiana. We work to protect Hoosiers through our several divisions and units. For example, we have almost nearly 20,000 active cases at any given time. Our office defends laws passed by the legislature and challenges federal overreach harmful to Indiana residents. We protect consumers from illicit business practices, cybersecurity threats, data privacy violations, and ID theft. We've obtained nearly $1 billion in settlements for Hoosiers. We also return over $1 million in unclaimed property to Hoosiers every week. And since taking office, Attorney General Rokita has recovered $85.5 million from entities alleged in Medicaid fraud. We handle almost over 1,000 criminal and civil appeals each year, and we've been successful in upholding the convictions of child abusers, murderers, and rapists. And under General Rokita's leadership, the ultimate mission of the office is to serve, protect, and defend Hoosiers by championing liberty, justice, and the rule of law. And that mission is what brings me here today to talk to you about regulation and enforcement of social work in Indiana. So, a brief overview of what to expect today. I want to dive in a little deeper as to the the division and units I mentioned, and specifically what divisions in the Attorney General's office focuses on licensing enforcement. I also want to go over a few statutory definitions. Beryl, did everyone receive a copy of the PDF of the PowerPoint? Nope. I should have asked you.
Nope, I will drop it in the chat and people can grab it from there.
Okay, so a few statutory definitions we'll go over. I won't read them to you, but you'll have them there in front of you. I just want to point out a few things that will be important as we go through everything today. And then talk about the investigation and prosecution procedures for the AG's office as it relates to misconduct by licensed professionals, as well as allegations of unlicensed practice. We'll talk about some common violations and charges that licensed professionals can find themselves in violation of. And then we'll briefly touch on telehealth. I just think that's important to touch on in this day of remote participation and everything. And as Beryl mentioned, I think the Q&A function is up and going. So if you have questions throughout, feel free to pop them in there. I can't see that on my end with my PowerPoint up, but certainly we'll work at the end to answer any questions. I think Beryl's going to try to answer any that she can as well as we go along. So as far as licensing enforcement goes at the AG's office, as I mentioned, we have the Attorney General over the AG's office. He's the state's chief legal officer, and our office represents the state in various matters. Underneath Attorney General Rokita are several different divisions, and one of those is the Consumer Protection Division. That division does everything from data privacy, consumer litigation. They handle robocall litigation, and one of those things that we also do is licensing enforcement. So that's where I'm housed, as well as about, I think, 14 other attorneys, and then we have a staff of probably 20 investigators who work on cases, and we'll talk about that procedure in a moment. But licensing enforcement is responsible for investigating any consumer complaint that's filed against either a licensed practitioner or any allegation of unlicensed practice. This is a list of the health professions that we have jurisdiction over. We also do cover professional licenses, so real estate agents, plumbers, funeral directors, but these are the health professions and mainly where I spend my time. Most of these are individual practitioners, so an actual person, but we do also have jurisdiction over pharmacies as far as an entity that we can pursue any charges against, as pharmacies are also licensed in addition to their pharmacists and technicians. And as you'll see here, we have our behavioral health and human services. So that includes all the social workers here today, and then 3 other types of counselors and therapists. So if you have your PDF, your PowerPoint available, you can kind of go along here. And I have a few statutory definitions I want to share with you. I'm not going to read these verbatim to you, but I do think it is important that you know where these definitions live and how they apply to the statutes that you might read, the statutes that regulate your license. So these are all hyperlinked. I don't know if that came through in the PDF, but if not, I can share the actual PowerPoint with Beryl. So you can just click on it and it'll take you there. So you don't have to Google everything. But first are some definitions that relate to what is considered a licensed social worker, clinical social worker, counseling, and counselor. Some of these might seem obvious, but I do think it's important to realize that there are statutory definitions of words that may have a different meaning in layman's terms. So when you're reading the Indiana Code, the statutes that regulate your license, if it mentions something about only this particular licensed practitioner can engage in counseling, it's important to know that what it is referring to is the statutory definition of counseling, which is listed here, because there are a lot of different meanings of counseling just in everyday language, and same with counselor. And then also psychotherapy and mental health diagnoses. Those have specific statutory definitions. And where this comes into play is looking at the definitions of licensed social worker and licensed clinical social worker. So what you'll notice in the practice of social work is that it does not include the use of psychotherapy or diagnosis. So what would be important for someone who's an LSW, you're wondering, what is my scope of practice? What am I allowed to do without a clinical supervisor? Then you can go and see the definition of what is psychotherapy, what is a mental health diagnosis, and based on the statutory regulation, if you're only an LSW, you cannot do those 2 things without your clinical supervisor. And we'll talk about some violations in a little bit and where this comes into play, and something that we see a lot in terms of scope of practice. But that's why I wanted to just go ahead and share with you these few definitions as it relates to the statutory and regulatory codes that you'll see as they relate to your license. So that's a lot of words. So let's move on to something maybe a little less wordy. So we have our investigation and prosecution of practitioner misconduct. Also, this is the same process for any allegations of unlicensed practice. And so this is just going to go through the process of how the state enforces violations by practitioners. So what happens is that all of our cases stem from a consumer complaint. There is a link here that will take you to the complaint form. Anyone can file a complaint. There's a section for who the complaint is against. We appreciate as much information as possible. Again, we have to have jurisdiction over the person in order to proceed with an investigation. So we need to be able to confirm that they're either a licensed practitioner in Indiana or that there's an allegation of unlicensed practice. So we appreciate complaints that are thorough. And when we get that complaint form, we do notify who's called the respondent, which is who the complaint is being filed against. And that respondent is given a chance to respond to the allegations to provide their side of the story, so to speak. In the meantime, our investigators who are overseen by the Deputy Attorney Generals will investigate the complaint. There's a lot of different investigative tools that we have at our disposal. It really depends on the type of complaint as to what we will do. But generally speaking, the investigators will talk to witnesses. They'll obtain records. A common thing is mental health records or employment records, depending on the allegation. We might consult an expert if it's a topic area that we just aren't entirely familiar with and need an expert's opinion. We also work with other law enforcement agencies and entities. So if there's also a police report that's been made or a criminal matter that's undergoing, then we'll work with the prosecutors and the police on that. We also work with the DEA, FDA, entities that you all as social workers probably don't deal a whole lot with, but we do work with other entities as well. And then following the investigation, the investigator will provide all the information that they found to the attorney and will make what's called a merit determination as to whether or not the complaint has any merit, and if so, if we are going to file administrative charges against the individual's license or ask for a cease and desist if it is unlicensed practice. And so what that looks like, so up to this point, let me go back to, if you've had a consumer complaint filed against your license that we've investigated, that complaint remains confidential only until and if we file any charges against you. So IPLA, unless they were the ones that filed the complaint, they don't know about it. The board doesn't know about it. It's confidential. We can't share information. Even with the complainant, we don't share, any of the records we found, et cetera. We just provide the outcome. Now, if we do decide that there's merit and that it's appropriate to prosecute the individual's license, then we will file either an administrative complaint if it's a licensed professional, or a motion for a cease and desist if it's an unlicensed individual. Again, first time the matter is public record. So up until this point, there's no information that's been provided to the complainant, to the board, or anyone else that this complaint has been investigated. But then it is, when we file the administrative complaint or the motion for a cease and desist, it is put on IPLA's website. It'll be on the individual's search and verify on their license, if they have a license. So it becomes public record at that point. We have some various rules that the proceedings are governed by. I won't bore you too much with that, but they are linked here in case you ever want to take a deep dive into how the procedures are governed. And then in order to resolve the administrative complaint, more likely than not, we either end up in an administrative hearing or a final hearing on the merits of the case. It's an evidentiary hearing, proceeds very similar to a trial in court that you might have seen on TV or in person, depending on where you work. And the state presents its evidence. The respondent will present their evidence as to why they are not in violation of whatever has been alleged. Or the parties can enter into a settlement. So the state may choose to offer a settlement that will entail a stipulation to facts and violations as charged by the state, and then some sort of sanction, which we'll talk about in a moment. And then similar to court, the respondent does have the right to attend the hearing and testify at the hearing. They do have also the right to obtain counsel, but that is at the individual's own expense, unlike in criminal court, where one would be provided if a respondent chooses to hire an attorney. That's at their own expense. And as you might hear me say later today when we're answering questions, the state cannot provide legal advice to respondents or to anyone. We're attorneys for the state, so we're very limited in what information and advice we can provide. In terms of the sanctions that I mentioned, on the left here you have a list of all of the sanctions that the board has at its disposal to impose on a respondent's license. So that's everything from revocation, which lasts for 7 years, down to a censure, which is kind of a verbal slap on the wrist, and everything in between. And in addition, they can also fine individuals up to $1,000 per count. And then on the right here, we have some of our typical probationary terms. These are not listed in statute like the sanctions are, but these are some common ones that we see your behavioral health board and then other boards impose on practitioners if they are to receive probation. And then, of course, if there's an individual who's found to be practicing without a license, then they're ordered to cease and desist. Let's see. So, speaking of unlicensed practice, in terms of social work, so we have a list here. Again, I won't read this off to you verbatim, but it's pretty clear as to what an individual can and can't do without a social worker license. We see a lot of times people calling themselves social workers, using the abbreviation LSW, or practicing as a social worker for compensation. And all of those things are not allowed under the law unless that individual has a license to practice under the article. And so this is what would result in the state filing a motion for a cease and desist, and perhaps the board ordering one if the state proved its case. I'll take a break here. I think do we have any questions? No, just barrel. Okay. All right. So while there's unlicensed practice, on the flip side, there's also exemptions to licensure. And again, I won't read through all of them because it's about 2 pages, page and a half worth of exemptions. But there are several individuals who, as long as they do not call themselves social workers, can engage in social work without a license. Some of these include more of the obvious, such as another licensed healthcare professional who's acting within the scope of their license, a student who's being supervised so long as they use certain terms like student or trainee. And then there's some religious exemptions for like rabbis and priests. There's a whole list. So if you personally are here today and you are not licensed, you're working on a license, or you're a student and you want to know if you're exempt from licensure, then I suggest that you read this thoroughly. I also have a little disclaimer in here, since the state can't, again, give you legal advice as to whether or not you're exempt. I always suggest that you contact a private attorney if you have questions about whether or not your specific activities are exempt under the law. Let's see. Oh. Okay, so now let's go into some of the violations that you could see a practitioner being charged with. We have kind of 2 tiers here. So one are violations that are applicable to all healthcare practitioners. And then we have violations that are specific to social workers. So I'm going to go over the broad applicable to all healthcare practitioners first.
Here, we do have one quick question.
Oh, okay.
So the question is, does the complainant attend the hearing as well, or just the respondent? And does the complainant ever come before the licensing board?
Yeah, good question. So that's kind of a call for the attorney, the deputy attorney general, to make when we are, planning our case and how we want to present the evidence to the board. So certainly sometimes the complainant would serve as a witness if they're willing and if it's necessary for the case. A lot of times this would be where there's been a conversation between maybe the respondent and the complainant who might have been the patient, that only they both can attest to, in cases of boundary violations, sexual assault, things like that, where we really need the complainant or the witness to testify to that before the board. And then those are instances where they would. So not always, but if the attorney feels like it's necessary to prove their case, then it is a possibility.
Thank you.
Thanks. Okay, so speaking of violations, again, these are the kind of broad violations that apply to all healthcare providers, so doctors, dentists, pharmacists. And there's a list here. We can see it's under this code section. If you ever need to go back and actually read the code. But essentially it says that if the board finds a practitioner has committed any of the following, then the board may impose disciplinary sanctions. And again, those go back from everything from revocation to a censure or to fines. So what we have here first is fraud or material deception. And then in these 4 categories, and obtaining a license typically covers renewal fraud. So, when you renew your license and you have various questions about kind of what's gone on in the past couple of years, criminal convictions, things like that. If you are fraudulent in answering that question, you answer no, and you know that you were convicted, in between your renewals, or in your application, if we have any students out there, then you could be charged with this. And in delivering services is another common one I see with behavioral health, or with healthcare providers in general. That would include billing fraud. So indicating that you've seen a patient for 55 minutes when it was really 30 minutes, and we're able to prove that. Then we have conviction of a crime. There's 2 separate categories for this as well. One is a direct bearing on a practitioner's ability to continue practicing competently. So generally speaking, that would likely be, again, if you were convicted of some sort of like Medicaid fraud, sometimes depending on the situation, drug possession, if it's indicative of an addiction while you're practicing. Or we have a catch-all category, a conviction of a crime that is harmful to the public. So that covers most other crimes. We also have, if you've continued to practice, although you've become unfit to practice due to these 4 categories. I won't read them to you verbatim, but you can see drug or alcohol abuse or addiction is one, as well as undertaking activities that you're not qualified to perform. So that would be a scope of practice issue. And I mentioned this earlier that I would go back to it. That's why it's important for LSWs to really read what they are allowed to do without supervision. LSWs cannot provide any clinical services without supervision. You can't graduate, get your LSW, and then go open a private practice. So that would be undertaking an activity you're not qualified to perform. And then we have these other 2, failure to keep abreast of current theory or practice. So you're doing something in your services to clients that is just not what is current and acceptable in today's practices, or physical or mental disability as well. We have lewd or immoral conduct and delivery of services. There's several more violations specific to social workers that kind of touch on this. But as a broad category, this would certainly cover boundary violations or any sort of sexual contact with a patient. Allowing your name to be used in connection with someone who renders services beyond the scope of that person's training. So if you are an employer and you are allowing an individual to practice without a license, then that could be a violation of your own. They might be charged with unlicensed practice as well, but you are also in violation of the rules regulating your own license because you are allowing them to practice under your name. And then also any disciplinary action taken in another jurisdiction on grounds similar to Indiana law. So for those of you who have licenses in other states, and if those licenses have been disciplined, then you can also receive discipline in Indiana on your Indiana license for that. We have drug diversion. So for those who work in a hospital, it's not super common with behavioral health providers because, again, depending on where you're working at. But if you are working in a hospital and have access to legend drugs there, then if you are caught and found to have diverted any of those drugs, that is a violation of your license. Similarly, if you perhaps have another license and you have prescriptive authority and you're prescribing to addicts, then that would be a violation of that law. Failing to comply with an order imposing a sanction. So let's say the board puts you on probation. They have a variety of rules that you need to follow while you're on probation. Maybe one of those is that you have a practice monitor. If it is determined that you've been practicing without that practice monitor, then you face a charge under this violation. Engaging in or soliciting sexual contact with the patient, I think, is pretty straightforward, as well as assisting another person in committing a violation. We do also have a catch-all in that statute, which includes a violation of pretty much any other state or federal statute that regulates your license. So that can be another section of the Indiana Code. Sometimes we see things like failing to provide medical records when they've been appropriately requested. That would be a violation of Indiana Code. The Indiana Administrative Code, or the IAC, we'll get into that in a moment. That's where the specific rules for social workers are housed. HIPAA is another large one that I'm sure you all are familiar with, but we can also charge for any violations as it relates to patient privacy. So we will go ahead and talk about the rules specific to social workers.
Carah,
I see, yeah, we have a question.
yeah, there's a couple in the chat. Oops. So one is, do I have a legal risk if I'm providing supervision to someone who has whose clinical license is on probation?
Yeah, so again, it's I need to be careful, and I can't give legal advice as to what that risk may or may not be if it were to exist. But what my suggestion would be to just ensure that you're looking at the laws that we just referenced, and then anything that we're about to talk about, and ensure, I think, the ones that you're probably looking at, if you're assisting someone else in a violation. So that would be my broad answer, would be to ensure that you're not doing that. And then unfortunately, I have to give my answer of, I would contact a private attorney and ask them any legal advice questions.
And I would only add that if you are providing supervision to someone whose license is on probation, because it's a requirement of their probation to have that supervision, then that would be one of those pieces you'd want to look at the order that that person got. Again, I am not a lawyer. Y'all know that. I'm a social worker. So none of this is legal advice. Then there's a question about what happens to people who make false complaints against a practitioner.
So, from a licensing enforcement aspect, if we receive a complaint, from a patient, for example, who claims that a social worker violated boundaries, and we are either unable to determine that that is true, or even if we determine that it's false, then the complaint is closed against the practitioner. Again, in the investigative stage, it's confidential. So the board hasn't been informed in terms of any legal recourse for the practitioner personally. That would have to be a question for a private attorney as to whether any recourse does exist. As the state's attorneys, we don't represent individuals in an individual capacity outside of state employees. So that would have to be a question for a private attorney if you were seeking some sort of recourse for if you felt like they had committed libel or something like that. But as far as the licensing enforcement aspect goes, the complaint will be closed, and no action would be taken against the person's license. I see a couple others here in the Q&A. I see, can someone with an LSW work in a private practice being supervised by an LCSW? Yeah, so as most of you likely know, when you're an LSW, you need to get clinical supervision hours in order to get your LCSW if that's what you're seeking. And so certainly you can get those hours in a private practice if it's a clinical social worker supervising the LSW. What we see often and what is a violation is an LSW opening their own practice. They have no supervisor. Sometimes they even have employees. That is what is not allowed. You cannot do any clinical work without direct supervision.
And then there's one more. Can you speak to health information records when leaving a company, contractor, or employee? Who is responsible for holding the information and ensuring security?
So that would be a good question for not
Somebody else.
Yeah, so for and generally speaking, if you have like a specific situation, you've left a practice and you want to know what you need to do, I again would contact a private attorney. Generally speaking, if you worked for a company, you worked for a hospital and you left, they're going to maintain those records. But that's a good conversation to have with your employer, especially if you're a smaller practice, to determine who's going to be responsible for maintaining those records as required by law, for safeguarding those records, and then also if any records requests are made, who is going to be responsible for complying with that. But if you have a specific situation, I would ask a private attorney.
I'm also going to just make the pitch that this is where having your own personal liability insurance policy can become very beneficial to you. For those of you who are NASW members, you know that we have a liability insurance, but those are the questions that your liability insurer should be able to answer some of these, and that's why I would do it. And then there's one other question around coaching, and what's the risk for an LCSW who also does coaching? And I am just going to propose that that's probably outside of Carah's scope of being able to answer that one, because would you get in trouble or not if you did coaching? And she can't. I will answer for you, Carah, and say that I don't think you can actually answer that. But Andrea, if you want to have that conversation later after the meeting, I'm more than happy to talk to you about that. And that's where we are. I think we're all caught up on questions. Thank
Yeah, thank you, Beryl. Yeah, and yeah, my only suggestion would be for that would be to again revisit the definitions of what constitutes counseling, social work, and clinical social work. But Beryl might be able to give you some better answers if you're seeking something more specific. I think also there is a question when you use the term board, are you referring to the social work licensing board or the Office of the Attorney General? Yeah, sorry if that was not clear. So when I say board, I mean the Behavioral Health and Human Services Board. So that is who licenses you all in Indiana, social workers, clinical social workers, also marriage and family therapists, addiction counselors, and mental health counselors. And so when I say board, that's who I mean. When I say the state or the AG's office, I mean my office. And the board, while the state acts in a prosecutorial aspect, so we bring charges against the license, the board acts as essentially the judges. They make the final determinations as to whether or not those violations have occurred, and if so, what sanctions they're going to issue against a license. All right, I think we're caught up. So let's dive back into some of the specific rules as it relates to social workers. And just in the interest of time, I won't go through all of these, but it is linked here, and these are just kind of these aren't verbatim, but more so kind of a brief wording of what each of the rules are. And so these are some things that the legislature has determined in concordance with the board that they really want to make sure social workers are abiding by. And we see this because these are things that sometimes social workers and other behavioral health providers have similar rules that they have to abide by. Because as you can imagine, depending on what practice you're in, if you're a behavioral health provider or you're a physician or a dentist, there's going to be different risks and different scenarios that pop up more often for some practitioners and for other types. So some of the ones that we see most often in my office and that we bring before the board are billing, so billing fraud, acting within the scope of competence, again, is a big one, LSW versus LCSW, or if there's, a particular situation where you have a client and you just aren't capable of giving them the services that they need, but you continue to do so, that could be a scope of competence violation. Similarly, referrals. Of course, practicing while under the influence of any alcohol or drugs, and probably one of the second biggest thing that we see are boundary violations. So exploiting relationships with clients for personal gain, getting them to give you money, things like that, or engaging in any sort of sexual activity or intimate relationships with the patient. And then not abandoning or neglecting a client is another common one. Going back to kind of our question about, leaving a practice, making sure that you are giving your patients, and if you're working with someone else, the appropriate amount of notice, making sure that those patients have somebody else to continue care with. And then very briefly, just in the age of, I know telehealth started before COVID, but I feel like especially now it's so common, and it can be very beneficial tool for behavioral health providers. So there are some rules specifically in Indiana for providing telehealth. I just want to make sure that individuals are aware of that. So if you are an Indiana licensed practitioner and you are physically located outside of Indiana and you are intending to provide services to a patient in Indiana, then there is a certificate through IPLA that you must have. And so that is where that certificate comes in. If you're in Indiana, the patient's in Indiana, you're just using telehealth video conference to make the visit more efficient or easier access for the patient, then this doesn't apply. This is just if you decide to move, you're located outside of Indiana, but you want to continue to treat Indiana patients, then be aware that this certificate is necessary. And just our little takeaways here that I hope that you got from this presentation. I know that I think we might have had a couple of students, maybe even a professor on here, but also our new and long-term practitioners. I think it's always helpful to remember the differences between LSW and LCSWs and what they can and can't do. Also unlicensed practice and exemptions. So certainly, if you are aware of someone who's practicing without a license, then you as a consumer are welcome to file a consumer complaint with the AG's office so that we can investigate that, and the board has the option to hear the case if appropriate. And then also, I hope that you've taken away the bulk of the statutes and rules that regulate your practice. I know you probably went through this in school. Sometimes statutes change, things get updated and added. But also, I always think it's a good reminder to us, to any professionals, including myself, to remind yourself every now and then of what specific rules you're expected to follow by virtue of holding your license. Let's see, I also have a list of resources here. Again, I'll send Beryl the actual PowerPoint, so they're all hyperlinked. We have the codes, the statutes and laws that we went through today. Also some information from IPLA, which is the agency that houses your behavioral health board. The U.S. Department of Health and Human Services has some really good fact pages on HIPAA. So if you have some questions about the privacy laws, what your requirements are, things like that, that website actually has quite a bit of guidance that is really easy to digest and understand. We mentioned health records. This is the statute that relates to the requirement to provide health records if requested, and then also your NASW Code of Ethics. And so now I'll open up for questions. My last slide, though, is a disclaimer, as I mentioned earlier and a few times already. This is just for informational purposes. I can't provide legal advice. This shouldn't be taken as legal advice, but I am happy to answer any questions that I can. And if I can't, perhaps Beryl could, or we can at least maybe point you in the right direction. So we'll go to the Q&A here. Let me stop sharing so we can see each other.
So there's one question sent to me. So the question is, what percentage of complaints filed are closed and not referred to the board, or are all complaints made to the state automatically sent to the board?
Good question. As far as a percentage, I'm not sure I could get that information. We do actually, provide a report to the board every meeting as to like how many cases we have open, how many we've closed, things like that. So that information is out there. I just don't have it off the top of my head. But they are not automatically sent to the board. So we go through the process of receiving the complaint, investigating it, and then only if it has merit and the attorney believes that charges can be filed, then will it be sent to the board in the form of an administrative complaint, which they are online. If you go to IPLA's website, there's a litigation area that actually you can search all of the complaints and final orders for the past several decades, I think. But but essentially it has, the state's alleged facts and charges, which would be the violations, and then asking the board to hear the case and make a final determination on those charges and if sanctions should be filed. So it doesn't automatically go to the board. If you have a consumer complaint, it's also confidential in case anyone came in late. Those consumer complaints are confidential. Only are they public record, and only will the board know once the administrative complaint is filed.
Thank you. There's another question about, is the telehealth certificate required when the practitioner is temporarily out of Indiana?
So I don't want to give you wrong advice because I am not sure on the specifics for that. I would go and look at the statute, and also on IPLA's website. It is pretty specific as to when those certificates are required, and there might be a time frame. If you're gone for 2 weeks, they probably, that probably doesn't apply. But again, I don't know. That's not legal advice. I honestly am not sure. I haven't read that part of the law. So I would double check if you're going on vacation and you want to be able to treat patients, while you're out of town. Double check before you do that, just to make sure.
And you can find all that information if you go to the PLA website. There's a search screen. Just put in their telehealth certificate, and it will take you to the page that explains everything. There is no fee for registering as a telehealth provider in the state. It is just a process. So, and it's, all things being equal, it's a pretty self-explanatory process. It's not as complicated as some of the other places can be. So there's another question about, when a claim is found to be without merit by the board and it's closed, is the practitioner notified that the complaint is found to be without merit and is closed?
Okay. So I think with that question, there might be confusion as to the consumer complaint investigation process and the actual litigation prosecution process. So they're two separate things. The investigation comes first. That is what is confidential. The board doesn't know about it unless IPLA filed it. And the respondent, the practitioner, is made aware when that consumer complaint is filed. So that could be any complaint, a patient, whomever your employer files, your ex-employer files against you. So it's investigated, and then it's determined if after that investigation that complaint had merit. And if so, that is when an administrative complaint, not to be confused with a consumer complaint, charges, for other words, are filed with the board. And again, yes, the practitioner will be made aware that those charges are filed. You'll also be made aware if the consumer complaint is closed. If the investigation has no merit, you'll get a letter that says, following our investigation, there was no merit and we closed it. We're not proceeding any further. If charges are filed, similarly, you will get a copy of the charges, and there's a cover letter that explains who the attorney is, that we're filing these charges. You have the right to hire a private attorney, and then also that the board will set the matter for a hearing, and you'll receive notice of that from the board. And then also, I didn't mention, I'm not sure if anyone's been to any board meetings, but it is interesting because we'll have the evidentiary hearing, and unlike in court where you have to wait for a judgment, the board will actually deliberate after the hearing in public and make a determination as to whether or not they found the violations, and if so, then what, if any, sanctions they're going to file or impose. So you'll know that day, but you'll also get final written notice of any order by the board. I hope that answered that question.
I think it did. Are there other questions? In somebody, if you don't want to type, you can raise your hand was going to say, I can unmute you, but you can unmute yourself. Kathy, go ahead.
I'm sorry, I have all these questions, Beryl, today. Thank you. Thank you, Carah. The only other question I have is when it is referred to the board. So if it's a social worker, you use all the board members for all the disciplines. Is that correct? It's not just the social workers. You have marriage and family therapists and addiction. So lots of people, even if they're not social workers, may be involved in that decision and sanctions.
Yeah, so when the hearing takes place, or if there's a settlement agreement and they're considering whether or not they want to accept it, then all of the board members take part in that hearing and the final determination. So that includes, like you mentioned, LMFTs, LCACs. There's a psychiatrist who is on the board, as well as a consumer member who is a registered nurse. So there's a variety of individuals who serve as what's called an administrative law judge and hear the case and make the determination together.
Typically, Kathy, the section of the board that is relevant to. So if the person only has a social work license, then two social work reps would lead the questions, with potentially of other folks asking questions or not, and those kinds of things. And the same for the other professions.
Right. I knew that. Thanks, Beryl. I just was trying to get the bigger grasp. Beryl, I want to thank you for having you, Carah. It's been very helpful for me to have a better understanding of the process. So I'm grateful that you took the time today.
And
thank you. I appreciate
I'm
that.
going to make a pitch. The board meetings are open to the public. Anybody can show up. If you, I know everybody has lots of spare time in their day. I know you all have lots of spare time in your day. But it's really, I have found it very educational to go in and to listen and to watch and to be there to hear kind of what's going on, what the discussions are, what the challenges are, those kinds of things. They just do a really nice job. So, the Attorney General's office does a nice job of presenting the cases, and it's all about the facts and the law. So the real important piece of all of this is to make sure that you know what the law says and what you can and can't do, and that you do your best to follow those rules and behave ethically as a social worker. So are there other questions or comments? If not, I would like to thank you very much, Carah, for coming in and being part of all of this and volunteering and asking and agreeing to come and present and letting me record it. I think it's been really helpful for folks. The one last question. So Francine, you can find the schedule for the board meetings if you go to the Behavioral Health and Human Services Licensing Board website. The meeting agendas are posted, and the dates, about a week out, they post the agenda for the meeting. It is subject to change, but you can actually then go in if you want to see what the complaint was. If there's you can actually go in and read those complaints on the same PLA website. And it really is, it's fascinating sometimes. I would say it's fascinating all the time. I should say sometimes. And yes, I am that nerd who likes to learn about all the different parts of this process. But Carah, thank you so much. I greatly appreciate you giving us your time and putting time into the presentation.